Hi. So I'm Kai. I'm the multimedia chair at the Harvard Crimson. And as a photographer, I've, through my experience, realized that the importance of knowing your rights as a student journalist truly cannot be overstated. And hearing them from an expert is really a lucky opportunity that we all have today. Frank LoMonte served as executive director at the Student Press Law Center for just over a decade, or just a decade, from 2008 to 2017, a resource that all student journalists should definitely take advantage of. Outside of that, LoMonte worked as a lawyer in multiple sectors, including government and nonprofit, after a career as an investigative reporter and columnist. Though he remains an active volunteer at SPLC, LoMonte currently heads the University of Florida-based First Amendment think tank, the Brechner Center for Freedom of Information. Please join me in welcoming to George this afternoon.
Great. Thank you. Thank you. I appreciate that. Yeah, this is, I think, my fourth year doing this, and the first time I haven't been knee-deep in slush here, so thank you for the much improved weather. Hopefully that'll bode well for your flights home. A little bit about me, a little bit about what we're going to talk about here today, and when they gave me a nice big window of time, so let's make sure that we save time at the end to kind of just do stump the lawyer here, throw at me whatever your trickiest legal questions are. We'll try to work through them together. So the Brechner Center that I've been running for about the last year and a half it's 42 years old. It's kind of a think tank about the public's right to know. And so we publish studies and do research about issues of access to information. I'll talk some about that research and about how that might be of use to you. Just keep us in mind as a resource. One of the reasons I love coming to events like this, and I'm so delighted to be invited back, was I learned so much just from listening to you about what those kind of persistent pain points are in your news gathering, the obstacles that you're running up against when you're trying to gather and share information. And so what we exist to be kind of a counterweight to that, to try to figure out strategies for people to get around those news gathering obstacles. So I want to hear from you about what those are. Before that, as Kai mentioned, I was the director at the Student Press Law Center. I'll have their website up at the end, but it's splc.org. They're on Twitter, and they're easily findable on all social media platforms. And for those of you who have not used that, it's a really wonderful resource, nonprofit organization based up in Washington, D.C. that has a network of over 200 volunteer attorneys around the country. In fact, I was one of them. That's how I got sucked into this. I was practicing law in Atlanta, minding my own business, and the next thing I knew, I was running the joint. I have always enjoyed doing this work because nobody enjoyed being a student journalist more than me. I was a college editor at the school that I now teach at the University of Florida, and it's still probably, of all the many really fulfilling jobs I've had, the best one, because every year you walk in with a blank slate to innovate on, and you're playing with house money. You don't have to answer to a hedge fund or shareholders, and you want to do something, boom, it just gets done. And I assure you that doesn't happen inside of higher education. So, so enjoy that and take full advantage of the freedom that you have to innovate. So my plan is, I thought I would go through some of the kind of recurring stumpers that people have posed to the SPLC and then to me, and I still take these calls, and I'm delighted to do it, from people who have issues about their legal rights, kind of hit some of the high points of things that people most want to know. And as I'm going along, feel free to jump in if you've got a story to share or if you want to elaborate on something. And then at the end, like I say, particularly if you've got a story that you've just been blocked on and stumped on and you want to work it through, let's crowdsource it with the group. So interestingly enough, because Kai mentioned being a photojournalist and mentioned the need to understand your rights, one of the first things that I like to always point out to people is that as a journalist gathering news in public places, you have more rights than you may think that you have, and certainly more than the people that you deal with think that you have. And it was so interesting to listen to the folks from Brandeis this morning about the adversity that they have encountered in trying to help people understand that when you engage in a public activity like a protest or a march or a demonstration, that there's a certain waiver of privacy that comes with that. And you don't get to declare portions of public streets or thoroughfares or the quad of the campus your own private personal space. That's just not how the law works. The law is very protective of the right to gather news in public spaces. And when sort of big picture point here, big picture lawyer point, because people get these calls or emails all the time from people saying, I'm mad at you and I'm going to sue, right? In fact, I'm dealing with one right now at a college in Illinois, not SIU, thankfully, but a college that's not here in Illinois, where they wrote about a scheme that involved a person trying to funnel some grant money to a fraternity, basically. I'll just keep this generic. Funnel some money to a fraternity that they were not entitled to get. And the fraternity, of course, is named in the news story, as any journalist would do. And the national organization contacts the university and says, we're going to sue you for using the name of our fraternity in a news story without getting our authorization first. That's exactly the reaction I was hoping for, all right? You got it. That's not a thing. Totally not a thing, right? Never been a thing, right? People don't get to say, don't publish my name or the name of my organization. We're involved in a newsworthy event without our permission. But that shows you sort of the disconnect between what you and I and people with, at least that much legal knowledge know is the law, and the people that you'll deal with as sources who sometimes are very have expansive ideas of what the law protects, and that they can, okay whether their photo appears on your website or their name, and sometimes it's your job to educate them. So one of the really persistent myths that just will not die is that there's some kind of a children's invisibility law, right? And so that if you get a child in your photograph or a child in your B-roll, that somehow you're invading the family's privacy and the parent can get that taken down. And again, not a thing. We're going to say that a lot today. Not a thing, never been a thing. I think where this grows out of, where this perception grows out of, is there are certain confidentiality laws that do apply to the way the government keeps records about kids, right? So like a juvenile court record, those kinds of things are not widely accessible to the public. But from that little acorn has grown this giant oak tree of misinformation where people are absolutely convinced that their children are their private personal property and that you can't put them in a news story without consent. And again, just not a thing. When somebody, I started to say about the fraternity, when somebody threatens you with a lawsuit, just really the exposure that you have, and by the way, this never happens. Nobody ever follows through with this in college media. People rattle that saber a lot, but they almost never take the saber out of the scabbard because they know that, in fact, the law is very protective of the right to publish. But there's really only two things that a person could even get past the door of the courthouse with. It's either got to be libel or it's got to be invasion of privacy. Those are the two things. So you ask yourself with libel, have I published a false fact about someone, or invasion of privacy? Have I published something, whether it's true or false, that was none of the public's business about somebody? And the reality is you're almost never going to do either of those things, right? And so that's the universe of stuff that you could be sued over. What's not on that list? Pissing me off, displeasing me, making me mad. Not on the list, right? All of those things you're entitled to do. In fact, you're sort of expected to do. We kind of need you to do those things. And so not a legal claim that could get you inside of the courthouse. So don't lose sleep over that. Don't take it lightly. Obviously, somebody makes a threat like that, bring it to the attention of, whether you have legal counsel at your program or whether you have legal counsel outside or SPLC. Bring it to the attention of somebody, but don't lose any sleep over it. It's just not a thing. One of the other legal misperceptions, I've had this call many times, people will send the camera crew or a photographer out to the scene where there's some kind of a disaster or a medical emergency happening, and there's some poor guy being loaded onto a stretcher, maybe after a car crash or a fire, and you see the person's face as they're being put on a stretcher and loaded into the ambulance. Have you violated their right to medical privacy? No. It's his bad luck to have been injured in a public place. When you get injured in a public place, you're engaging in an activity that is a matter of public interest and concern. The test for whether you have a right to photograph and videotape something, this is really bottom lining it, is this a space? Is this a space where a person would have what is called a reasonable expectation of privacy, right? Reasonable expectation of privacy. I would just shorthand that to, is this a space that you would even contemplate getting undressed in? If it is a place where you would drop your pants, then it is a place where there is an expectation of privacy. So what are those places? hotel room, locker room, dorm room, right? Obviously, private home, hospital room, nursing home room. That's it. We just covered the universe of places where there's a reasonable expectation of privacy. What's not on that list? Street corner, sidewalk, right? The lobby of a hotel. None of those places are private spaces. And if somebody turns up in your photo against their wishes, they have nothing to bring to court on the basis of invasion of privacy because it's just not a private space. Okay, so good on that. Good on that. Now, having said all that, while journalists don't have any inferior legal rights to the rest of the public, they also don't have any superior legal rights to the rest of the public, right? So you see that yellow crime scene tape where the police have put up, you don't get to wave your press pass and say, oh, good, I'm just going under it, right? I mean, no, you're still a trespasser, and so you don't get to, if the best live shot that you can get is in the intersection of Main Street and University Avenue, you don't get to plant your tripod there and block traffic, right? That's still a crime, whether you're a journalist or you're just a bystander. And so all the same laws that apply to everybody else apply to us. You don't have any superior rights, but you also don't have any inferior rights. And so a policy that says, everybody is allowed to come take pictures of this crime scene except for you with the press pass on, that would be an unconstitutional policy if enforced by the police, right? And we'll talk a little bit more about that in a moment. But so don't think that your press pass stops bullets. It doesn't. But you certainly can't be charged with just news gathering in a public space, right? If your feet are planted, think about where your feet are planted. If your feet are planted on a place where it is legal for them to be planted, then everything 360 degrees around you that you can see is yours, okay? And as long as you're not trespassing in that space, that's all your stuff to record, to photograph, to videotape, and very importantly, this now clearly includes police activity. And this is a point of friction and conflict that journalists have all the time, that you show up at a crime scene, and this tends to be kind of the smaller, less experienced police departments that don't interact on a daily basis with the media. So not the Washington, D.C. police, but the Mayberry police, and those folks oftentimes feel like they own the crime scene, and here you are, you're an interloper, you showed up with a camera, and you're messing with my crime scene. I don't want you there, and I'm going to take your camera away, right? Or I don't want to be on TV. I don't want to show up on YouTube. Cops are very sensitive about this, right? They don't want images of them showing up on YouTube where they can be ridiculed. And so the federal courts are now unanimous in saying that it is First Amendment protected news gathering activity to take audio, video, and stills of the police doing stuff in public spaces. In fact, one of the landmark cases in this area happened right here at Harvard. That's the Glick case, and have it right here on the Harvard Yard. A passerby, not even a journalist, just a bystander, happens to see the police in an altercation with somebody that they're taking into custody, and the person is screaming and thrashing around, and they think, oh, I may have a police brutality situation. I'm going to whip out my smartphone and start recording this, and the police decide that person, too, is going to jail because they violated what was at the time a Massachusetts law against eavesdropping, that by recording the voices of the police engaging in this arrest, that they unlawfully eavesdropped on a conversation, and this goes up to the federal courts, and the circuit court that's based in Boston here says, nope, out you go. That is not a constitutional application of the wiretapping law, the eavesdropping law. You cannot prosecute somebody for just recording the police doing police stuff in a public place. So I think we're very clear that the First Amendment protects that. Now, this is where stuff gets really tricky. The First Amendment very, very clearly protects the right to publish the news that you already have, right? Who here has had like a media law 101 kind of a class already? Not that many journalism majors here. Okay, all right, yeah. So I met a lot of history majors and poli-sci majors last night, so okay. Well, in Media Law 101, right, what they will teach you about is stuff like the doctrine of prior restraint, right? The idea that the government does not get to tell a publisher what they can and can't publish. And so if the Washington Post has leaked Pentagon documents that were given to them by a whistleblower, the government can't go to court and get a judge to enjoin the distribution of the Washington Post, right? We've fought many battles at the Supreme Court to establish this principle, and it is now ironclad in the Supreme Court case law, that you cannot stop the presses, right? That much is very clear. It is actually really surprisingly unclear whether the First Amendment also protects the right to gather news in the same way it protects the right to publish the news. This much news gathering we know is now protected. That's clear. But the scenario that we're really waiting for the courts to sort of weigh in on, and I know that some of you have had this scenario, is you show up at a speech, let's say, right? Justice Ginsburg is coming to your campus, and it's a state university, and it's public property, and it's a public building, and it's underwritten with public money, and you'd like to go in there with your camera and your recorder and cover it, and they say, I'm sorry, this is a private event, you're not admitted to this, we're not allowing journalists in. Does the First Amendment get triggered there? And the answer is we have no idea. After 200 years of litigating this stuff, we still don't know. It is very clear that the First Amendment would not allow the government to prevent you from actually publishing the recording once you had it, right? I mean, that's clear. But do you have a right to insist on going in there when someone is barring the door to you? That's not clear. The First Amendment case law just hasn't been well developed in that area. And where this comes up from time to time, and for us who teach media law, the Trump administration is just the gift that keeps on giving, because every day is another final exam already pre-written for you, because they're testing the boundaries of the First Amendment. Seems like on a weekly basis there. And one of the who remembers the Jim Acosta case from this past year, right? I mean, this was a brain teaser for us in the First Amendment legal field. Was, does Jim Acosta and CNN have a First Amendment right to insist on keeping their media credentials when the White House says, no, you're not welcome here anymore? And again, right, we know that if it's a public street that Acosta can gather all the news he wants, and that's protected by the First Amendment. Could the White House single out an especially disfavored reporter and, using their governmental authority, say, you are personally not welcome here anymore because I believe that you've engaged in, you've broadcast viewpoints that are detrimental to the image of the presidency, right? Lots of us in First Amendment land think that that's too far. Lots of us think that while you don't have a right to demand the press credential in the first place, right? You or I couldn't just show up and say, I insist on being allowed into the White House with my camera right now. Once you set up that system, once you say, yes, we will offer press credentials to duly authorized members of media organizations, you can't say, oh, except for you over there because you're too liberal, right? You can't start picking and choosing based on viewpoints. We think that's what the law of the First Amendment says, but that one didn't end up going to court. So again, we're not, and this is what invariably happens with these cases. These news gathering cases are all really time sensitive, right? And so what invariably happens is either they get resolved in some way or they just go away because, the Ginsburg speech is one afternoon and it's there and it's gone. And if you don't get into court in time to get the credential, what am I going to spend the next 2.5 years arguing over the speech I didn't get to go to, right? So they just don't get litigated that much. So we're waiting to find that out. This is the one that, if you don't remember anything else that I show you, if you remember this, you'll already be ahead of 95% of the professional journalists that are out there, because this is a really powerful law that almost nobody knows existed. And I'll tell you the backstory to it. So back in the 1980s, the Stanford Daily newsroom is raided by the police. What happened is there was a protest on the campus of Stanford University, and some demonstrators occupied one of the administration buildings, and the police believed, understandably, that while the Stanford Daily was Johnny on the spot there, they had the best photos. We're going to want their photos so we can identify the people who were trespassing there so we can arrest them. And so they show up in a show of force and they raid the newsroom, and this is before digital cameras, right? So everybody's got film cameras, and they confiscate the cameras and they take them down to the station so they can look at the film and decide who to arrest. Well, Stanford Daily gets a lawyer and says, I think you got both a First Amendment problem here and a Fourth Amendment problem here. Fourth Amendment protects you against illegal searches and seizures, right? And it goes all the way up to the U.S. Supreme Court, which comes back in 1979 and says, nope, we don't see any violation here. They went to a magistrate, they got a warrant, they served the warrant, and in keeping with a normal procedure for a search, and so we don't see a constitutional problem here. Sorry, Stanford Daily, you're out of luck. Well, Congress is outraged by this, and then the following year they come back and they pass the Privacy Protection Act statute. And what the Privacy Protection Act, remember I said, You as a journalist don't have any superior legal rights to anybody else. This is the one exception to that. This is the one time when the law says you stand on superior footing to everybody else. Because if I am just a private homeowner and a police officer comes to my home and says, I'm here with a warrant from a magistrate to search your house, my answer has to be, come right in, officer. That's all I can say, come right in, officer, or else I'm going to go to jail for contempt, right? When you're in a newsroom, you get to say, sorry, come back later and shut the door, because the Privacy Protection Act says that that warrant is not enough. A warrant, right, is just issued by a magistrate judge usually, and it's issued by the police officer just on that officer's say-so, and you don't even know it's coming, right? That's sort of the whole point, right? They want to surprise you with the search. You don't know that it's coming. But with the Privacy Protection Act, Congress said, no, when it's a journalist and when you're searching for their journalistic work, we want you to have warning. We want you to have a heads up. And so that warrant is not enough. What the law enforcement has to do in order to search a newsroom is they have to go to a court hearing where you are represented by your own counsel, and then you get to argue why the reporter's privilege might apply to your work. And so you get to say no to that search, and you get an opportunity to fight against the search in a way that a private homeowner would not. Now, by the way, this was passed back in 1980 when nobody had a smartphone, and it said, it was called, kind of by shorthand, the Newsroom Anti-Search Act, but in fact it doesn't say newsroom in the law. It says any place where a journalist stores their work product. So today, where is that? Your smartphone, right? I mean, that's where most of you store most of your unpublished work products. So if a police officer grabs that smartphone and says, hey, I see that you've been filming at my crime scene, and I'm going to look inside of this, and I'm going to confiscate these images because I think they might be evidence, the answer is you're in violation of federal law. We actually had to use this a handful of times. I had to use it at James Madison University a couple years ago. I had to use it at Purdue University a couple years ago, where police were not informed about this, where they did confiscate journalists' cameras in order to search them for images. And both times, after being educated about the law, they immediately gave it back. But I do know that that law is out there, and do know too that the police cannot, this happens a worrisome number of times, that you're at that crime scene, you're at a riot or disturbance or a protest, some kind of chaotic scene with a lot of law enforcement, and the police start grabbing cameras and saying, I'm going to look inside of here, or I'm going to delete the images off of the hard drive. That is not within the range of things that the police are allowed to do. And law enforcement has been successfully sued over and over again for doing just that, both under the Privacy Protection Act, and frankly, it's probably also a First Amendment violation to do that. And so if an officer is demanding your camera and demanding to search it or destroy the images out of it, I would never personally acquiesce to an order that says, I am telling you to delete the photos out of this. I would not acquiesce to that order. I would never get into a physical tug of war with a cop. You're going to lose because he's got a bigger gun. But what I would do is say, I can't do that. These are not my photos. These belong to a news organization. I can't. I'm not allowed to do that. And make that person do it. Make the law enforcement officer do it. Then you'll have a much clearer legal violation. If they want to grab it out of your hand, obviously let them. Don't tug back. Let them take it. Make them delete it, and then you have a much clearer violation of law. And of course, now, right, that everybody's got a cloud-enabled device, either your smartphone or a camera. When you're going to one of those protests or demonstrations, someplace where you think there might be friction with law enforcement, always think about upload all the time, right? Because that camera may go away for a while, and you want to make sure that that the news doesn't go with it. So any questions about that? Or, yeah.
Is this all material, or is this just pertaining to images?
All unpublished work products. So yes. An audio recording of an interview would be covered. Notes would be covered, right? Anything that is unpublished journalistic work. Yeah, go ahead.
So whatever subject to subpoena.
Mm-hmm. And the answer is a subpoena is a little different than a search warrant, right? A search warrant is, I am going to come into your home, I'm going to come into your newsroom, I'm going to open your trunk, right? That's different. Subpoena is, show up in court or show up at a deposition and give your testimony or bring in your stuff. And at that point, that's when the reporter's privilege law in your jurisdiction really starts to kick in. And that's why we have reporter's privilege laws, right? And every state has it. Unfortunately, we haven't yet been able to, despite 50 years of intense effort, to pass one in Congress. And so the federal courts are very unpredictable about whether they will or not recognize a reporter's privilege. But thankfully for you, you're rarely going to be interacting with federal law enforcement, right? I mean, I don't know how many times any of you does a story where the FBI is involved, right? Pretty rarely. And so you're interacting with local law enforcement, meaning that those are cases that go through the state courts. And when it goes through the state court, then the state reporter's privilege kicks in. And so, and there are many flavors of reporter's privilege. There are some that are very broad, and there's some that are very narrow. All of them apply to your interactions with confidential sources. All 50 of them apply at least to that, and then some of them are quite a bit broader than that. So, you know, as soon as you get that subpoena, fortunately, they'll always have some lead time to respond. That's when you get a lawyer on the phone right away and say, you know, I think I have good grounds under the reporter's privilege to resist this subpoena, and I want somebody to try to, the legal term is quash it, right? You get an order quashing the subpoena, and journalists are pretty successful in doing that. Yeah.
Typically qualifies as a journalist because if you're employed or like freelance or just like a citizen out filming.
Yeah. This is, in fact, there was a very screwy court ruling out of Nevada recently that is on appeal right now, and that many people think is going to get overturned. But a judge refused to afford the reporter's privilege to like a blogger in Nevada and said, well, I'm going to use membership in the State Press Association as my definition of what qualifies as a journalist. And since this person didn't have a membership in the State Press Association, everybody thinks that's wrong. We all think it's probably going to get overturned. But you can see where judges are really wrestling with this, right? Because they want to come up with some dividing line. I mean, the nightmare scenario, if you're a law enforcement official, is that, you know, somebody's going to witness a bank robbery, right? And you need their testimony to identify the bank robber. And the person is, you know, they're just a Joe average citizen who happens to have a Twitter account. And they're going to say, oh, I'm sorry, now I'm a journalist because I tweeted it. And they're going to refuse to testify in court to nail the bank robber, right? And so that's the nightmare. So they want to come up with some dividing line somewhere. Yeah.
It's published.
Right, yeah, but what the police will normally want is your testimony, right? They'll want you to come in and say, this is what I saw, and I can identify that, you know, there's your robber right there sitting at the table, right? And journalists get to say, no, I'm not going to come in and testify. So what they don't want is for people to just kind of put the journalist hat on and say, oh, because I have a social media account, that makes me a journalist. I don't have to testify against the bank robber. So, you know, I get it. I understand that. I would feel the same way. So the majority rule seems to be that if you have a history of doing journalistic stuff, that is enough to make you a journalist. There was a really interesting case up at San Francisco State University, this goes back about 10 years ago, where a guy who was taking photos for a laboratory course, it wasn't even, you know, at the behest of a news organization, but he was making a capstone project for a laboratory course. He got to claim the protection of the reporter's privilege, and part of what tipped the scales in his favor was he was able to show, well, I have sold freelance photos to news organizations in the past, so I have a history of doing journalistic stuff, and that seems to be enough. There's a handful of states, Texas is an especially bad one, unfortunately, that have a really narrow statute that says you have to be doing it as a like substantial part of your livelihood, you know, and so that person who sells one photograph a year is probably not going to qualify, and you know, it's questionable whether a college journalist who doesn't receive any salary would qualify in a state like Texas. I mean, I always tell people, don't assume you don't have the privilege. I mean, always assume you have it, because like once you waive, you waive. Once you give it over, you give it over. So always start with the assumption that you have the privilege and that, you know, you're entitled to claim it, and then get thee to a lawyer right away. Go ahead.
One of the questions I had is basically on going back to people taking photographs in public. I was told by Brian McDermott, he's the chair of the journalism department at the University of Massachusetts. He said that you are allowed to do that, and you're allowed to take photos of police officers in public, as long as if your method of photography or recording is not discreet, and so you have to. I believe that he said you can't. It can't be something like you're doing it in secret. Like you have to be in public. Is that a real thing?
Oh, interesting. So, I mean, that is a non-frivolous argument for this reason, because one of the bases for those court cases that we talked about is that when you are a police officer doing stuff in public, you have no more expectation of privacy, right? I mean, you know that what you were doing is a matter of great public concern, and you were doing it in a space where, you know, anybody walking by could hear and see you. And so I suppose it's a non-frivolous argument to say, well, but if I'm standing around there and my camera is, you know, inside of my coat and I'm just, you know, sneaking photographs of you, maybe I still have my expectation of privacy, but I don't think a court is going to buy that. I don't think a court is going to buy that. I think either you're in a place that's private or you're not. So I am not aware of any court ruling that has said, like, yes, you have to announce yourself as a photojournalist in some way. I don't think that's really the law. Yeah.
Inside buildings of public universities. Is that, are you still giving that exception of this is a public place, or is that now a private place?
It's really a space by space question. And so the answer is that there are spaces inside of those buildings that are private and spaces that are not. So let's say you go into the library, right? I mean, the lobby area of the library where, you know, anybody would be welcome to go and, you know, use the bathroom, get a drink of water, whatever, right? That's not a place where anybody has an expectation of privacy. So if you take a photograph there and somebody shows up in it and is unhappy with being photographed, the answer is, I'm sorry, that's just not a private space. Once you go up inside the library director's private office on the second floor that has a locking door on it, right? No, you know, I mean, if you sneak your camera through a crack in the door and get a photo of the guy, you know, that is an invasion of privacy because a person doesn't expect to be photographed, you know, sitting inside their private office with their door pulled, right? So the answer, it's a very space by space question. But these are two different questions, right? Question number one is, could I be sued for invading somebody's privacy there? And the answer is almost certainly not. But do I have a right to insist on going there? That's a very different question. So if the library security person comes up and says, please stop taking photographs in the lobby of the library, you're annoying the other patrons, do I have a First Amendment right to insist on being there? It is not clear. That gets back to my point about we don't know that much about the boundaries of the First Amendment right to gather news outside of the police context. So, I mean, I think that the answer to many of these questions is going to come down to, were journalists singled out in a discriminatory way, right? Like I've told student journalists this in the past. Has anybody had the situation where you're told by like the food concessionaire at a food court that you're not allowed to photograph in a food court area? I used to get that question quite a lot. These people like the concessionaire contractors would say, you can't take a picture of somebody, you know, assembling a Blimpie sandwich or something because we regard that as a private space. And, you know, do you have a right to insist on remaining in the food court after the manager has told you, no, we have a policy against photography here, please leave? Again, I don't know that you have a great claim, but you have a much better claim if everybody else around who's eating at Blimpie's is taking cell phone photos and they're not bothering them, right? Which, you know, I mean, it's 2019, that's happening, right? And so if they only single out the journalists and they say, oh yeah, well, if you're eating a sandwich, take all the pictures you want, but you as a journalist are sort of uniquely uninvited to take photos here, I think that's First Amendment problem. I think that's First Amendment problem. Yeah, go and then go. Yeah.
How is the matter complicated when it's a private campus and you know students paying tuition to a private university, and you also have campus police, not like state police?
So I think the two questions are still the same, which is it an invasion of privacy that somebody could sue you for? No, because, you know, the library here, let's say, right? I mean, I went into the Harvard Law Library yesterday. You know, I'm not a tuition-paying person. I don't have an ID badge. You know, I was welcome as a visitor to walk around inside of that lobby. And so any place where people are welcome to walk around inside of is not a private space, right? So still no invasion of privacy, even on privately owned property, but your First Amendment argument for gaining access to in the first place goes completely away, right? Now you're not dealing with a government agency anymore. Now you're dealing with a private business. And private businesses, right, including your own, including this one, are not subject to the First Amendment. And so if they decide to make rules and regulations, with one exception I'm about to show you, they decide to make rules and regulations that are restrictive of speech, they get to do that. The Constitution just doesn't kick in. It's just like any other business, you know? I mean, if I go to, you know, Macy's department store and I have a, you know, protest protest sign in my hand as I'm shopping in menswear, right? They can say, I'm sorry, we don't allow political protest in the menswear department, get out, right? And I can't say, that's a violation of my constitutional rights. No, I mean, I'm a guest at Macy's. They get to make their own rules. And so, yeah, it's just, your school is no more protected by the Constitution than that. Yeah, go ahead. Yeah.
So now that more and more news outlets are getting on social media, Snapchat is really, really interesting because unlike other social media platforms like Twitter, Instagram, Snapchat, you essentially you have the ability to take a photograph of somebody and you can do it directly, and that photograph will only stay on for maybe 10 seconds, 5 seconds, and it'll be gone. So in terms of even if police did want to be able to search your private Snapchat, once it's published, how would they be able to access that information now that it's gone like that?
So super interesting. And the answer is, like, thankfully, because cases take a very long time to get through the federal courts, we don't know yet. I mean, that technology is just too new for these cases to have bubbled up through the courts in the way that the police ones have. I mean, I think, right, the answer is that if it is something that the police care enough about, and this is normally, it's the exception, it's the international drug trafficking ring, right? It's the national security thing. It's that 1 in a million case that law enforcement really cares about. Then by golly, they'll find a way to do it. They'll go to Snapchat and they'll get a warrant there, and you'll find out that those things don't really disappear. There's a backup copy on somebody's server somewhere. And this is how, like, text messages have been retrieved. In fact, this is sort of a very scary thing for all news organizations, is this idea that, the reporter's privilege is great, but if somebody can go to Google and get a hold of my GChat history without my even knowing that they got it, right? They've now end run the reporter's privilege. And so will that happen? Invariably, I'm sure that it will. But, if it is just getting a copy of the snap, right, you don't really have a good privilege argument for that anyway, because you publish that. The privilege is about the unpublished work. And so, would I assert a reporter's privilege against, something that I'd already put on social media? No. But, would they be allowed to grab your phone out of your hand and start rooting around to try to see if they could retrieve it? No, they certainly wouldn't be allowed to do that. Yeah. Go ahead. You had one. Let's move on. Yeah.
And I'm assuming this would fall under a private space. Every year, I think one of the yearly things that college papers cover is the students moving into the dorms.
Yeah.
Is it a private space in a dorm if you're going and you're photographing and you're trying to get like them going in with their boxes and they say, oh yeah, go ahead and come in with us to take pictures? Can a university, at a public university, can their housing people say, no, this is private, you cannot be here as a journalist?
Wow. Yeah. And again, right, this gets back to that same access question. I think that the answer is still going to get back to, is there discriminatory enforcement against only journalists, right? In other words, if I have my friend Bob on one hand, my friend Susie on the other hand, and Bob has a press pass and Susie doesn't, and she's gonna come in, right, with her smartphone and live stream me on Facebook Live on her personal platform as I move in, right? And Bob's gonna do the same for his news organization. If they let Susie in and not Bob, right? And I think then we have a First Amendment problem. If they're applying their rules selectively only against journalists, even though lots of other people now have publishing outlets, then I think we have a First Amendment problem. But do I have 5 federal appeals court cases to point to? No, I don't. I mean, this is all new stuff, and we just don't have enough body of litigation there. But, in general, because those are places where people are doing private stuff, right, and where there would be some degree of risk. People are changing their clothes and they don't pull the door shut all the way, and so it's open a crack, or they go out in their pajamas to go fetch something out of the refrigerator, right? I mean, I think that that would be one of the harder places to demand access to as a journalist. I mean, of all the places that I've heard of universities enforcing those limitations, I think a dorm would be the hardest case for a journalist, because that is a place where there's a bunch of sleeping quarters where you might potentially, observe somebody in a state of undress or whatever. The ones that I think are better cases that I would like to see somebody try are these speech type cases, right? Where somebody comes to the campus and they're using an auditorium where everybody else is invited to go except journalists are disinvited. I'm really dying to see somebody bring those kinds of cases. Do you have one like that?
Sorry.
Yeah.
I know of a situation that happened at our school a couple years ago where one of our reporters went into it was like like a discussion or like an open forum kind of thing. And they told her that she was allowed to take notes, but she wasn't allowed to take pictures, she wasn't allowed to record, and she wasn't allowed to quote anyone or use anyone's name.
Wow, yeah. So legally, I think where this would come down, right? There's sort of a difference in the eyes of the law between something that is a like ticketed access controlled event on the one hand versus something that's not. So if it's a ticketed access controlled event, oftentimes that ticket will come with certain contractual conditions attached to it, right? Like you buy a ticket to an NBA game and you go and you sit in the bleachers, you won't realize it, but you've just signed a contract. You know, you have purchased a license to use that bleacher seat for the next 2.5 hours, but it's subject to all of the conditions on the back of the ticket and on the website, and some of those would include, right? Don't whip out your smartphone and live stream the whole game, and if we catch you doing that, we're going to eject you and revoke the license, and your ticket is now canceled, right? And so in the same way, I think a ticketed access controlled event, they probably can say, well, you know, Justice Ginsburg has said she doesn't want to be videoed during this event, and so we're enforcing a no videos policy, and you as a journalist have you know, by virtue of being a ticket holder, you are now subject to the no videos condition. And I think that they can do, but again, it comes down to, are they selectively enforcing it against just journalists? Interestingly enough, and I think people have, you know, this is one where I sometimes have to deflate journalists' expectations and bring them down to earth a little bit. People have an indignation about, well, what do you mean this, you know, I don't have a right to go cover this. This is everything about this seems governmental. It's a government official like Justice Ginsburg who's being paid to be here, and a government-built auditorium that's everybody involved in this, organizing this thing is a government official. How is this not something that I have a right to insist on going to? And the answer is that, you know, states have what are called open meetings laws, right? And that's the extent of your state statutorily protected right to go to stuff. Is this a meeting of a board or a committee of some kind? But a speech by Justice Ginsburg is not any of those things. And so, you know, my sort of come back down to earth point to that is, well, you know, the U.S. Supreme Court is a government-funded organization that's meeting in a government-paid building, but do I have a right to demand to bring my TV camera in there? No, I don't. I'm going to be shot if I do. And so, right, the answer is just because it is a governmental activity taking place in a publicly built building does not appear to entitle us to insist on journalistic access to it. So anyway, all right, let me move forward here with the oh gosh, yeah. This is, I got a whole garage full of soapboxes at home, but this is one of my biggest soapboxes. You're gonna see a couple of them today. But so this is what I've really been focusing my research on in the first 1.5 years at Brechner Center, is when I started talking to journalists about like, what should I be focusing on? What are the things that are most bothersome to you? Right at the top of that list was nobody on my beat is allowed to talk to me. You know, I cover, you know, Microsoft, or I cover the, you know, University of Georgia or whatever, and nobody on my beat is allowed to talk to me. The sheriff's department, the school district, they're all instructed that they have to filter everything through a PR office, and that the PR office will return the phone call, and often they'll just email you back some kind of a canned, prepared statement that seems very inauthentic, and you're stuck using that. Well, come to find out, there are both in the public sector and, surprisingly enough, in the private sector, legal workarounds for this. In the public sector, we're getting ready to publish a big research report on this, but in the public sector, there are many decades of case law by the federal courts saying that if you tell all of your employees at this governmental agency, including a public university, that they are forbidden from speaking to the news media, that is an unconstitutional restraint on their speech. In the private sector, and I don't think anybody in this room is at an institution that would be exempt from this. There is a narrow exemption for super religious, like a Liberty University type of institution. But if you're not at Liberty, you know, at most private organizations, including Harvard, and most private business entities, it would be a violation of federal labor law, the National Labor Relations Act, to tell everybody there, you are forbidden from speaking to the news media. And again, decades worth of case law saying so. No one knows this exists, and everyone is acting like it doesn't. It is like the 55-mile-an-hour speed limit. Yeah, it's there, but is it observed? No. But does that mean it's legal to drive 80? No, it is not. Just because everyone is doing it, right? That doesn't work on state troopers. It's not going to work on me either. Your university says, well, what do you mean? This is a state-of-the-art policy. All the universities have this. The answer is, yep, and they're all driving 80 in a 55 zone too. This is not legal. Go ahead.
Do you have any idea if this also applies to like private high schools or?
So a high school is going to be a little trickier for this reason. The federal law applies. The trigger for federal authority, right, is do you do any interstate business? That's the trigger. The federal government can only regulate people that do interstate business, and so not mom's candy store. And if it's a private high school, you know, with 200 students that only recruits from the local area, then it's probably not doing interstate business and it's probably not subject to this law. On the other hand, if it's, you know, a 2,500 student high school in New York City that gets people from Connecticut and New Jersey and Pennsylvania, then yeah, it probably is subject to it, as long as it's not a super religious. When I say super religious, I mean, because like lots of institutions, you know, like Duke is sort of nominally a religious institution, it's founded by a church, right? But it's not overtly religious, it's not teaching church doctrine. Unless you're teaching church doctrine, then you are covered by this. So the answer is like some really big private high schools probably are, or certainly if you're part of a chain, right? Part of a chain of like charter, not charter schools, private schools, right? If you're a chain of private schools, then they probably are subject to it. Yeah, go ahead. I see a lot of questions about this one. Yeah.
Yeah. So you wrote forbidding all employees. So does that mean forbidding any employee is also in violation of the act?
So yeah, I'm glad you asked this. There is some nuance to the federal one. In the land of the First Amendment, at a public institution, the answer is everybody there has First Amendment rights, everybody there. It is a little different in the private sector on the NLRA. The NLRA is about protecting non-management employees. So in other words, if they say the athletic director can't talk to you without the PR person approving it, or the vice president or the provost can't talk to you, they can do that, right? They're not violating those people's rights. Well, I'm thinking about, you know, the beat cop, right? The person that works for the Harvard Police Department, right? If that officer says, I'm sorry, I'll get fired. I was told I'll get fired if I talk to media. It's right here in the employee handbook. The answer is that's illegal. And I want to hit the question on this, but like, really important point in First Amendment land here, really important point in First Amendment land, because people will respond all the time when they're told like something violates the First Amendment, right? Their immediate response is, well, I know about the First Amendment, but we have rules here, or we have contracts here, or we have a handbook here, and we go by the handbook. And you know, whenever you hear somebody say, I know about the First Amendment, but I know about the First Amendment is a complete sentence that ends in a period. There's not a comma after that. You don't get to contract your way around the First Amendment. And so I hear this argument all the time. Well, but we gave the officers an employment contract, and it says right here, you waive all your First Amendment rights. It's like, imagine if the contract said, like, you know, you have to shave your head and convert to Hare Krishna to join the police force. Do you think they can enforce that? You think if somebody said, I'm not going to do that, they would say, well, it's right here in the contract? I mean, no, they can't make you do that kind of stuff by contract. And so there's certain rights you can't contract away, and one of them is the right to freedom of speech. So that's just, it's again, not a thing. Go ahead.
It seems like whenever I personally have tried to talk to anyone from the Boston Police Department, they'll always say that they are not allowed to talk to me and I have to talk to their media person. Is that...
Police departments are where these cases get brought most often, and in fact, I even think there may have been one brought by officers of the Boston Police Department. I really think there may even be one on the books. And my answer to that is always, right, I would ask to see the policy in writing. I would ask to see, where are you getting this from? You know, was this something that was in a memo or a handbook or something? I want to see this in writing. I would ask the superiors, you know, where is this rule exactly about? Because oftentimes you find out that the rule isn't real. The rule is just some like word of mouth thing that's been passed down from recruit to recruit, right? Like, don't let the boss see it in the newspaper or you'll be in trouble, but it's not really a rule, right? But if it, and I can't do anything about that. I mean, it's just the culture of the department, right? If everybody just chooses not to speak, you're out of luck, right? I mean, the First Amendment entitles them to choose to speak, but it doesn't compel them to speak. So if they choose discretionarily, like I just don't want to get in trouble, I don't like controversy, I don't want my name in the newspaper, can't do anything there. But if they're saying, I would be happy to talk to you, but for the fact that we have this rule, now we've got a First Amendment problem. Go ahead.
So we had a situation with our housing department, shocker, where they've unofficially instructed all like student employees that they cannot speak to the media.
I was waiting for somebody to tee this one up. I was waiting for this one. Okay.
I've like addressed it with the director of housing and our vice chancellor for student affairs, and we're at a public state institution. And they said no such rule exists. You know, if they want to talk, that's fine, but you know, we've told them that they can't talk on behalf of housing. They don't have that authority to. And I said, that's fine, but there's been instances where we had like a residence hall catch on fire. We had another one with like a pipe break, and people have told us we would talk to you, but otherwise we'll get in trouble if we do. But there's no written policy, but that's what they've told them. So what do you do?
So, and this is where sort of I think a lot of employers are taking advantage of exactly that nuance that you just described, which is if they were to put out a memo that says, do not hold yourself out as an official spokesperson of our institution, that is a lawful policy. That they can do. But if somebody, right, so if somebody wants to say, well, right, on behalf of housing, I would just like to reassure everyone that the building is safe, right? That they can't do, but they can certainly say, you know, yes, I witnessed it. Someone leaped out of a third floor window. I saw it with my own two eyes, right? All that stuff is constitutionally protected speech, and they could not be fired just for giving you that much information. So my number one tip for that is get that on the record. It sounds like you have, and publish the hell out of that and keep doing it. You know, I mean, reinforce that every year that, oh, the university has confirmed that contrary to what seems to be a widespread belief, there is no policy against RAs speaking to the news media, and make sure that they know that, you know. There's a very good story, and I'm slightly biased because I'm quoted in it, but it is in the SUNY Buffalo Spectrum newspaper that just came out over the past week. And if you look at the SUNY Buffalo Spectrum website, there is an extensive story about exactly this First Amendment issue in the RA context. And I think RAs are probably among the most gagged employees throughout both public and private institutions, and they're the ones that seem to be the most frightened of talking, understandably so, right? Because like, not only are you controlling my salary, you're controlling my house. And I mean, if I get fired, I'm on the street. And so they're the people with sort of the most to lose, right? Nobody has yet asked me about athletes, but you should, because athletes are a very interesting case, and I really hope people will start to write about and to question these gag orders on athletes. At a public university, I'm very convinced that almost every public university is violating the First Amendment when they tell their athletes. Somebody said something about mandatory media training if you're allowed to talk. Yeah, that's not a thing, not a thing. No, if they were to punish an athlete, right, if they were to punish, and this is right, the First Amendment comes into play when the government uses its regulatory or punitive authority, right? So they can certainly offer the training. They can certainly say, you know, we think it's a good idea for you to have this training before you speak. But if they say you are not allowed to speak and there will be consequences, you'll be kicked off the team, you'll lose your scholarship, whatever, if you do, that's when you trigger the First Amendment, is when governmental authority is used to impose consequences on people for constitutionally protected speech. And again, could they enforce a narrow gag order? Yes, they could say, don't give away the secret trick plays that we're going to run in Saturday's game. That they can say, right? Not a violation there. That's necessary for the team to be able to do its job, right? But if they say, don't talk to the media about anything relating to your, you know, football player status, way too broad, right? Because there's all kinds of things that you might say just as a, you know, you might say, you know, I want to talk to you about growing up as an orphan, you know, I want to talk to you about, you know, that's not compromising any confidences in the football team. So there's lots of things that people could say that would not in any way interfere with the operation or effectiveness of the team. Go ahead.
It's about being an RA. So I'm an RA and I'm also a reporter at my college. So that's fun. So one of the things that, like you said before, that RAs at the University of Massachusetts are not allowed to talk to the press. They have to refer the press to UMass News and Media Relations. So I know as a journalist, if an RA wants to talk to a journalist on their own volition, just because they want to and they know the consequences, that's fine. I've gotten in quotes and interviews from RAs themselves.
Okay.
But if you said it's not against the gag rule for a university to say that, okay, you as an employee, you can't talk to media directly, but we can refer you have to refer them to the UMass.
No, that they can't do. That is unlawful to tell that the people who work for a public organization, you are required to give no comment other than to refer it to a spokesperson. That is against the law. It is decades of case law saying so, right? They cannot do that. What they can do is they can say, you may not speak as an official representative on behalf of the organization. You are not authorized to make statements of like policy, right? That, well, you know, on behalf of the housing department, here's what I have to say, right? But you can certainly share personal opinions. If the policy doesn't make that clear, then it is an unconstitutional policy.
And then for student athletes, I know our sports reporters, they always talk to them about what's going on in the field all the time, but are student athletes not allowed to comment on, okay, I think about this about the athletics department, or, oh, our football team, you know, I think this. Are they not allowed to talk about logistical things?
So there's a difference between, that's a great question, right? So what we're primarily talking about now is the blanket policy, right? The blanket policy that says don't talk to the media about anything, or get approval first, or get training first, right? All those things are illegal. If you then talk to the media and you give away something that somehow interferes with the ability of the employer to operate, now you have departed from your First Amendment protection, right? So that if you were to just blast the coaches and say, these people are idiots, they don't know what they're talking about, I could call plays better than the coach, every one of them should be fired, we should start disobeying them and calling our own plays, right? Now you've departed from the protection of the First Amendment. Now you're interfering with the orderly operation of the program. But if you were to say, I don't support Trump's reelection for president as an athlete, right? You're not interfering with the ability of the team to operate. You know, that's a personal opinion. Nobody believes that to be an official policy statement of the athletic department, right? So that's the kind of thing you're allowed to say, or you're even allowed to comment about, the conditions under which you work, right? Like, yeah, I think college athletes should be paid for their work. We work really hard, right? If you were to say that and the college were to say, oh, I'm sorry, we're yanking your scholarship for talking to the media, boom, we're in First Amendment bonus time there. So that's a problem. Yeah, one more and then I want to move forward. Yeah, go ahead.
You said for like an athletic department saying that you can't talk to athletes because of media training. Hypothetically, if a reporter kept talking to athletes and pumping out stories, are there repercussions for the student? Reporter?
Constitutionally, there should not be. I mean, the question is always, and I'm glad you brought this up, right? Because like the students will at times get intimidated by authority figures at their university, and it's easy for me to say this. I mean, I get it. It can be a very intimidating relationship. I often tell people that, especially if it's something you feel strongly about, you may need to actually look the authority figure in the eye who's telling you this and say, what will you do to me if I refuse? What will you do to me? It's like drawing the line, step over this one, sucker, what will you do to me if I refuse? Because the answer may be, you know what, I actually can't do anything to you. I mean, the answer may be that it's really more of a request than it is a requirement, Now, in sports, of course, this is, again, a really interesting gray area that I can't give anybody too much reassurance about because we don't have any court cases about it, is the credential. That's the one power that they have over sports journalists that doesn't exist really anywhere else in government, which is, do I have the ability to get my sideline pass? Do I have my ability to get in the press box? And we've certainly seen that happen to news organizations where they've said, you know what, you've just pissed me off one too many times, no more sideline photo passes for you. Can that hold up under the First Amendment at a public university? I'm not sure. I'm not sure that it can. And remember, we're only talking about public agencies, right? So if the NFL does it, they're a private corporation. They can do all that all they want. At the public university, I'm not sure. I mean, there's just a small handful of cases, and they're not very helpful. They're not kind of on point with this situation. But if the athletic director literally said, you know, look, I told you to not interview my players, and you did it anyway, so I'm now yanking your press credentials, I think there are at least the basic ingredients for a good faith First Amendment claim there. Would you win? I don't know. I don't know. Yeah, one more real quick, but then. Yeah.
So in the off season, let's say, I know how football works, right? The football players are not doing their football thing right now.
Yeah.
I don't do sports. I really don't do sports. I just do news and photo.
Yeah.
So if you were to interview a football player and they were to say like, oh, I don't like my coach, you know, he's this, he's that, he's that, this, that, he's doing a terrible job, and it's the off season, does the gag rule still apply?
So again, right, gag rule is about, can you even have the conversation at all? Gag rule shouldn't apply, period, right? Like, can they impose consequences on that person for making that statement? That is an illegal gray area where you're calling out the coach and you're potentially undermining the ability of the program to operate successfully, right? We don't know. I will say this, if you change one fact a little bit, if you said, I don't like the coach because he makes people run sprints in 100-degree heat until they faint and have to receive emergency medical treatment, now we've got whistleblowing, right? And so I feel like that's protected speech. But if you just say, I think this coach thinks and he's an idiot, is that protected speech? I'm not convinced that it is. I'm not convinced that it is. But that's why it's a good idea to challenge these things on the face of them as a gag order before you get into one of those gray areas. And I wish athletes would start doing that. I really want to move forward from this. We've got a lot of other stuff to cover, but come, grab one of my cards or talk to me afterward if you're at an institution that has one of these, and do get a hold of those policies in writing, because I'm collecting them. I want to see them. I want to start bringing some test cases. I want to identify the ones that are the most vulnerable in places where we have the best First Amendment judges, because I think these are all like dominoes, and they're going to start toppling over. Real fast here. Okay. FERPA privacy. This is probably the most frustrating response that people get all the time to requests for records, right? And like, you should take FERPA the way you take the sticker price on a used car, right? It is only the beginning of the negotiation. It is not the end, okay? Because it's almost always the case that universities and schools define the universe of FERPA way more broadly than the courts do. I mean, FERPA was passed to fit a very specific concern by Congress back in the 70s. And the specific concern was they didn't want K through 12 schools giving away minor disciplinary scrapes that kids got into and giving it to the police so that the police would start profiling people as, potential future criminals. They didn't want the cops going rifling through the disciplinary records at schools to figure out who to put under surveillance. And for that reason, Congress passes FERPA and says education records, and that's the term in it, are confidential. Well, over the years, we have seen these university and school lawyers try to define everything under the sun as an education record. And the reality is that you can find a court case that says anything you want. The judges are all over the map on this. But don't assume that the assertion of FERPA is right. There are a couple of very specific statutory exclusions that everybody should know about. I mean, we can argue and we can haggle over the gray areas in FERPA, but these are not gray. These are right in the law. Law enforcement records, not FERPA records. So if your police department is blacking out the names of people in the police reports, claiming that FERPA requires it, they're just wrong. That is right in the law. Same way, results of a disciplinary, so like a student conduct board hearing. Joe Jones get called in front of the student conduct board. They conclude that Joe Jones committed 2 rapes, and they expel Joe Jones. That piece of information, Joe was found responsible for 2 counts of sexual assault, and his punishment was an expulsion, is all exempt from FERPA. It's right in the law. Congress said so. So in that narrow set of circumstances, only if they're guilty, not if they're not guilty. But if they're found guilty of something that would be a violent crime if it happened anywhere other than a college campus, then that much information is not protected by FERPA. Now, most of you are at private institutions. Can you compel people to give that over? No, you can't, because they're not covered by public records laws. But it's still not a good objection for them to say, oh, I'm sorry, I would love to help you. I'd love to answer that question for you, but FERPA forbids me from doing that. That's not there. It has not been there for many years. Congress amended the law back in the 90s with the specific intention of making sure that people could find out if there were like rapists running loose on their campus who had not been expelled, right? And so this is this is an exemption that many institutions like to pretend does not exist, but that is not protected by FERPA. Boy, I just want to sort of blow through. I'm going to just flag a couple of these things, and then if you want to talk afterward, we can. Anyone's at a private institution, if you haven't looked at the IRS 990 report for your institution, you're really missing out. There are stories to be had there. Any nonprofit corporation has to file their tax return every year with the IRS, and it's a public document, unlike certain people's tax returns, which shall remain nameless, right? It's a public document that we get to see if you're a nonprofit organization. And so if you're Tufts, if you're Harvard, if you are the athletic association at the University of Florida, if you are the teaching hospital at the University of Florida, all these tax returns are public documents if you're a nonprofit corporation. And this is like a snapshot of their budget. You get to see how much should they make and how much should they spend. Really quick here. I pulled a couple of these. There we go. So this is what one of these would look like. I just got off guidestar.org, and guidestar.org is a free service. You can just sign up, get a free account there. There you go. Right, that's one. Right, that guy. This is what one of these looks like. And, it looks like the tax return that you and I are, going to file in April, except it's got many more zeros on it. So, this one happens to be, and I pulled this for a reason. This is the Big Ten Athletic Conference. And so athletic conferences are nonprofit organizations that have to show their tax return. And so, if I were at a school that was in a power conference, I'd be pulling these every year to look at what the conferences are up to. And I don't know how much you can read here. I'm sorry, I'm going to go off the mic a second here. But so this Big Ten conference, that it actually shows that in the most recent year of this return, and I'm sorry, this is an old return now, so don't get excited about breaking the story, it's a couple years old, that they actually overspent their budget by $10 million. They lost $10 million in that year. And when you go through the tax return to look into why that might be so, let's see here, I'm not connected. If you go through the tax return to find out why that might be so, oh, here we go. Yeah. Right, what you find out is the difference between those 2 years. Look at line 15 up there, salaries, compensation, employee benefits, went from $7.8 million to $13.6 million in 1 year, and that's why they lost money, right? So that's a story. Who quadruples their salaries in a single year? That's bizarre, right? Something weird happened there. And you're gonna find stories like that if you dig into these tax returns, and they have to give them to you. Yes, go ahead.
So I had a question about the tax returns. So when you want to look at how an organization spends their money on administration versus donations, where can you get that information besides like an organization's website without taking their word for it?
So in a private organization, you will see a certain degree of that in these tax returns. For example, you can see in the expense category, if you have very good glasses on, there's a line on there that talks about professional fundraising fees, and then beneath that, total fundraising expenses. So like if they threw a banquet and they spent $500,000 on this banquet, that would show up as a fundraising expense. And that is a very interesting thing to look at in nonprofits, because a lot of them, right, they'll announce, hey, we raised $2 million at the banquet, hooray for us. And it turns out that the banquet cost $2 million. And so they wound up netting nothing, right? And that's a good story to do. Are they using their money wastefully on, luxury type events that don't actually net them any money? So know that those 990s are out there and that those are public documents that you're entitled to get. Everybody's at least a little bit familiar with the Clery Crime Reporting Act, right? Looking at the room here, yeah, so I'm not gonna spend a lot of time on that other than just to sort of remind everybody to put that on your calendar every October that, you gotta get that annual crime report that comes out every October that shows the statistics on serious crimes, but kick the tires on those statistics because they often are wrong, and especially when it comes to sexual assaults, they're usually suspiciously wrong. You'll see a big campus with 30,000 people that will say they had 2 rapes, and that just doesn't seem like it can possibly be right? And so that's the time to start going into investigate mode and find out, well, who compiled this report exactly, and who did you talk to, and where did you get these numbers from? And what you often find out is that the reason that the numbers are so low is that they're only counting the things that they responded to as a crime within the police department. And that is only a small subset of what the federal government requires you to report. The federal government says if anybody in authority on the campus learns of a sexual assault, boom, that's a check mark in the box, and you got to count that. So the athletic director or a coach or a dean or an advisor to a club finds out that somebody was sexually assaulted, the housing director, boom, that's a check mark in the box. Are colleges doing that reliably? I'm not convinced that they are. I think a lot of those numbers are deflated, and they're only reporting the ones that go to the police, which, as we know, are a small subset because many go through student conduct instead. Yeah.
So, hypothetically, that's the case.
Mm-hmm.
Then is there like a record where they're keeping track of this, or something that would be public record that would show, hey, you're not reporting everything, you're only reporting the subset of a larger set of data?
Probably not. The best you're going to be able to do is to get them to explain to you the process, right? And if you get them to sit down and say, why, yes, I, as the director of public safety, sit down every year with the police chief and we go through the police reports and we count up the number of incidents, and that's how we decide what number goes in the box, then you know that they did it wrong, right? To do it right, what they should be doing is reminding the people on the campus in authority all the time, you have a duty to report this up the line. You have a duty to report this up the line. And I would ask people that who are going to ask the dean of your own college, do you know how and where to report one of these things if it comes to your attention? Has anybody trained you on doing this? Do you even know who to call? The answer is probably they don't.
As a follow-up to that, at our university, we're mandated reporters. So what do
as a journalist?
Yeah.
Oh, you're so not. That's totally wrong. Yeah.
So because we're student employees that we're mandated reporters, so how do you report on sexual assaults and sexual violence when?
The answer is change that policy. Yeah, I got that policy changed. The federal law says you have to be in a supervisory type of a position in order to be a mandatory reporter, right? You have to be an authority figure of some kind. So a student reporter is not, under federal law, a mandatory reporter. So your university is going beyond what is required under federal law, and I think unconstitutionally. So if they're telling student journalists, you can't have a confidential conversation with somebody who wants to share information with you about a sexual assault without triggering the mandate to report, I'd take that case any day of the year. That's just not right. That's just not right. Yeah. All right. I want to. I've just got a couple minutes left, and I'm just going to put SPLC's info up here, and I wanted to hit a couple of things that are not directly on the script, but just a couple of sort of wrap-up points here. And then one wrap-up point, and I was so happy to hear this referenced in the morning, was the existence of campaigns around the country to pass what are called New Voices laws that protect the autonomy of student journalism. I know in this room we've got people from Florida, from South Carolina, from Texas, from Ohio, and from New Jersey. Those 5 states have got active campaigns going on right now to pass statutes in their state legislature that protect the independence of student journalism at the college and the high school levels. New Jersey, Texas, and those are the 2, New Jersey and Texas, that have active bills that are in their legislature right now. Those other ones, Ohio and Florida and South Carolina, we'd love to see somebody introduce a bill, but I think we're a year away from doing that. But there are 14 states right now that have these. I regret for those of you who are at private institutions, so far, with one very small exception, we have not been able to convince states to extend that freedom of the press to private organizations. That's just been a bridge too far to get legislators to do that. But those of you who are in those states that are targeted New Voices states, like New Jersey and like Texas, please be using your editorial page to urge your legislators to pass these laws. They're overdue reforms. We should have them in every state. And it's shameful that a state like Florida is trailing behind Kansas and North Dakota in having these protections. It's embarrassing. So that's wrap-up point number one. Wrap-up point number two, I can't believe we got all the way around the room last night without somebody mentioning, in your favorite news stories, I got to give a shout out and a plug to who here has been listening to the In the Dark podcast from American Public Media? A couple of fans. Oh, everybody should be listening to this. I was just out to dinner with somebody from ProPublica a couple of weeks ago, and he said, I think In the Dark is the best piece of journalism done in the year 2018, period, full stop, in any medium. And that's coming from ProPublica. The season 2 is the one to listen to. In the Dark, season 2. It is all about taking apart a criminal case in a rural town in Mississippi where a district attorney has now put the same guy on trial 6 times for a quadruple homicide. He's on death row right now. This is just life-changing journalism. These people spent a year living in this small community in Mississippi, taking apart this case and introducing all sorts of reasonable doubt. And you'll thank me for it. It is a love letter to public records. This case. This is all about the power of public records to do good things, and the power of journalism to do good things. And actually, that's a good place for me to wrap, which is I want to show you. During my time at Student Press Law Center, one of the things that I called on to do, and you should definitely take advantage of the opportunity to do this, is to do pre-publication libel review on sensitive stories. And this is the most memorable of the ones that, let me see if I can zoom this in a little bit, that I worked on. It's from 2013. It's called The Final Barrier is the name of it. It's from the University of Alabama newspaper, the Crimson Y. And I sat up with these people until about 1 o'clock in the morning as they were getting ready to run the presses, and went through this story with them. And this was a story, this is 2013, that could have been told on just about any college campus in America. It was certainly a phenomenon that existed in a lot of them. But in Alabama, where the Greek system is powerful, second to no other institution in this country, this is a real third rail lightning rod story. And yet they went there and they told this story about how in the sorority system at University of Alabama, there was only one documented instance in the entire history of the university in which an African-American woman had been admitted to a predominantly white sorority. And a couple of things about this. I mean, first of all, forget everything that your reporting professors have told you about that it is forbidden to start a story with a quote. That is true unless your quote is, quote, are we really not going to talk about the black girl? That's the lead of the story. And that was a comment relayed to them by a person who was in one of those decision rooms where they had an overwhelmingly qualified black applicant for the sorority that they didn't even bring up for nomination for one reason and only one reason. And so when you get that quote, you're allowed to make it your lead, okay? So this was really brave for these students to do. I mean, the Greek system, as I say, is just, it's not only powerful on the campus, it's powerful in Tuscaloosa, Alabama. The Greek system runs local government. Everybody in local government is a product of the Greek system at the University of Alabama. And the second thing about this is my sort of one editing point to leave you with. As I was going through this story with them at midnight on the day before presses ran, what I did and what I encourage you to do as editors is I just went fact by fact down this story and I asked them for each thing. I said, how do you know this? How do you know this? How do you know this? And that's my Swiss Army knife editor question that I will leave you with, right? When somebody makes a claim or an assertion about a fact, you want to be sure that you really know that it is a fact and not that you're repeating something that somebody heard secondhand through the rumor mill, right? And so especially when you're doing a narrative like this, where you're putting people inside a closed room where decisions get made and you're purporting to be able to tell them conversations that happened in a closed room where journalists were not, you better sure be confident that the person telling you this was in the room, right? Not, no, somebody told me 2 weeks later what happened. Nope. it's got to be somebody in the room. And by golly, they had somebody in every room. I mean, this was an airtight story. And even though it exploded across the country and they got all kinds of negative reaction from their campus, nobody could ever poke a hole in the solidity of this story. And it not only changed their university, it changed sororities everywhere. I had a friend who was at Columbia at the time who said, we had an emergency meeting to ask, do we have an Alabama problem here? And so it reverberated all across the country. So that's the power that you have to make positive change. That's the power that you have if you're ambitious enough and if you're courageous enough and you dare to do big things with it. So go forth and make change. Thanks, guys.